Am I audible and the screen is visible now?
You are audible, but the screen, I don't know. I am seeing only the bottom part of your screen.
Yeah, one strip is only visible.
Oh,
Maptal version 1.
1 minute.
Yeah,
Now, hopefully, the full slide is visible.
visible.
Okay, great. So, this case actually, my history is also there with this case. So, when we were reading for CA, this was one of the case laws that I had come across. I don't think I had read it fully then, and I hadn't imagined it would be like this vast and all of that. But the concept of unjust enrichment itself was something extremely interesting for me then as a student, and somewhat that drew me to indirect taxes per se. So this case is very close to me and why I came to indirect taxes that way. And thank you, Venu, for telling me, giving this case to me. I think this is the first time I really read this case through and through, though I would have read it in bits and pieces for various other matters earlier. And it's a beautiful judgment. I think all of you have to read it. I don't think I'll be able to make justice for what is how the judgment has been drafted and what are the principles laid down, but I will try my best. And this is a 300-page judgment. So if I really go in detail, we can go on for multiple sessions, but I will try and restrict it to 1.5 an hour so that we have enough time for discussion and sort of conclude the entire judgment in today's session itself. So I'll firstly go through the facts of the case, what really happened, and then go over what the principles are, and then go over how the judgment came out, what were the arguments, and what were the logic behind how the judgment was decided. Okay, so Mafatlal Industries was a textile mill in Ahmedabad, and it was manufacturing blended yarn, paid excise duty till March 1972. And this blended yarn was captively consumed by other mills for the manufacture of art silk. So there was this another company called Calico Mills, similar business of manufacturing blended yarn. They said that this levy of excise duty on blended yarn is ultra vires, and they went to Gujarat High Court. Gujarat High Court ruled in their favor, and they got refund of the taxes that they had paid, or basically they didn't go ahead and pay the tax in case of Calico Mills. So looking at this precedent, Calico Mills case, Mafatlal filed a suit for refund of the taxes paid under mistake of law. And the trial court or the civil court agreed to Mafatlal. They gave the refund. The Union of India or the Revenue appealed to Gujarat High Court. Gujarat High Court held that Mafatlal and others should prove the loss of injury to claim refund. And similarly, and that is how it came to Supreme Court, because Mafatlal did not agree with what Gujarat High Court said. They appealed to Supreme Court, and it went to Supreme Court for to be decided by the bench of 9 judges. So a little more history over here. What was happening here was, I think in Calico Mills, if I'm not wrong, the excise duty was not paid. Before paying the excise duty, they went and filed a case, and they got that the blended yarn was ultra vires. Mafatlal went ahead and paid the duty till March 1972 and asked for refund. So the major issues were these. Is it essential for the person to claim refund to establish unjust enrichment or loss? Is it open to claim refund under Section 72 of Indian Contract Act, or should the statute of indirect taxes, whether it is customs or excise, whether the statute should be followed for filing the refund claim, whether writ or civil court is a way for claiming the refund, or strictly statute application under statute should be filed. So mainly the refund provisions were like this.
Danish, the previous slide ones.
Yeah. This one?
Yeah.
Yeah.
So the petition under Article 226 of the Constitution is the High Court, appeal to High Court, right?
Correct, correct.
So this was examined by the Supreme Court?
Yes. So basically writ, I would say both High Court and Supreme Court. So the Supreme Court examined whether refund can be filed under writ to High Court or Supreme Court, whether that is a valid maintainable writ, or whether refund can be filed under civil suit, or whether refund has to be done under the statutory provisions of the particular act. This was the question that was examined.
Why did it travel to 9 bench, or it was under review petition again went to 9 bench?
Correct. So all that happened. So there
Okay.
was it was under 2 bench, and then it did not, the Union of India did not agree, and then it was reviewed, and then it went to 9 bench. So
Okay.
it was a long drawn matter. I think 1972 they started, before which this Gujarat High Court was, I think 1984, Calico Mills came to final conclusion. By then, these people had already filed filed a suit to the trial court, and they got a positive order. And then the revenue filed an appeal and all of that. So it went up till 1972, where Calico Mills itself was given a favorable ruling. And then you can imagine this went up to 1997. This is when Supreme Court finally ruled. So 1972 to 1997, it went on till that long.
Got it.
So basically, this is the background of refund provisions till Mafatlal ruling. So up to August 1977, Rule 11 was what was prevailing. Rule 11 of excise rules. I'm not able to recall which, is it Senvat rules or what? I'm not able to recall, but it was Rule 11 then.
Not Senvet. Senvet came in
2004, correct?
2002.
2002, yeah. So rules under the
Moderate.
rules must be, yeah, correct. Yes. So there were only two things in that rule. Application of refund should be filed. Limitation of 3 months was the only rule, was the only provision, or was the only thing which was under Rule 11. Then between 1977 to 1980, Rule 11 was amended. These were the additional provisions. Application had to be filed, limitation of 3 months. No limitation if tax is paid in the protest. So once the tax is paid in the protest, the limitation doesn't apply. And till the judgment or the ruling comes for the dispute to be settled, the limitation doesn't apply. And the limitation is only after that for 3 months. No refund except under these rules. Refund as a result of order. Refund. Okay, if there is a refund as a result of order, refund can be done without application. That was one thing that was there in Rule 11 amended. Then after that, what happened? From 1980 to 1991, Section 11B came into being. So there the application had to be filed, of course. Limitation of 6 months from the relevant date. No limitation if the tax paid under protest. Refund as a result of order. Refund can be claimed without filing the application. And if there is a mistake of law, I will explain what mistake of law is in my subsequent slide. If there is a mistake of law, refund has to be claimed only through application, and no jurisdiction of the court is valid, or all the courts are barred. No refund except for refund under these provisions. Then there was this Amendment Act of 1991 from September 91. There, this incidence of tax, evidence of incidence of duty not passed on, had to be proved. Consumer Welfare Fund was introduced. and it said no refund except for these provision. So this part, mistake of law, refund application only, that part was not, sorry, this part, refund as a result of order, refund without application was completely removed. So basically 1991 said all refunds have to be filed via application. All refunds are under the statutory provisions of the Excise Act, Section 91, Section 11B. Consumer Welfare Fund and some of these other provisions were introduced. Section 11D, Section 12A, 12B, 12C, 12D, which these are some of the GST provisions. I will not go very detailed into this because, of course, paucity of time and we must be knowing these provisions already. But I've just drawn parallel to where GST is coming in. So 76 is that where any amount is paid, any amount is collected, represented as duty or tax, it has to be all paid to the government. 11D and 76 have been similar. In 76, it also says if the tax is not paid, then notice will be issued, penalty has to be levied, and assessment will be done. Similarly, 11D also, there was a assessment to be done, and if the tax is extra, if the tax collected is extra, it would go to Consumer Welfare Fund. Similarly in 76 as well. 12A said the price of the goods, there has to be a document which indicates price of the goods, and similarly Section 33. 12B and Section 49(9) of GST Act says presumption that the incidence of tax has been passed on will, the incidence of tax will always be presumed to be passed on unless specifically rebutted. 12C and Section 57 talks about Consumer Welfare Fund and utilization of the fund. Yeah, so the situations in which the judgment talks about which are the situations under which the refund would arise. These are three situations: unconstitutional levy, illegal levy, mistake of law. Right? Unconstitutional levy means where claim for refund would arise on the ground that the provision of the act under which the tax was levied is struck down as unconstitutional. So in the case of Mahfat Lal, what had happened, or in a few other cases, the provision was later struck down as unconstitutional because of various, like you would go, there would be a dispute raised to the courts, and the courts would ultimately rule that the provision is unconstitutional. If the tax is paid before that, for such cases, the refunds, the judgment says that the refund arises outside the provisions of the act and file suit or writ. However, unjust enrichment has to be proved. So, for example, I am paying tax for, let's say, very simple pen, I will say, for example, I'm just finding this pen. So I'm paying tax and for this pen, but I will discover or I will come to a conclusion that this tax on this pen is unconstitutional. So I will file a writ or I will go to the courts saying that whatever tax I have paid, first of all, is not valid, and the tax on this pen itself is unconstitutional, so strike it down. So once the court strikes it down, the refund would arise as a consequence of the ruling, as a consequence of the judgment. And to get that refund, I'll have to specifically prove that the incidence of tax has not been passed on. Illegal levy is where claims for refund arise on the ground that there is misinterpretation, misrepresentation, or misapplication, erroneous interpretation of act, all of that, where I'm paying tax extra without fully understanding the provisions, or by understanding the provisions wrongly. Whatever taxes I'm paying, those refunds arises under the provisions only under this act. That is, application has to be filed and just enrichment has to be proved. Mistake of law is typically what happened in Mahfat Lal's case, where in somebody else's case, the mistake of law was proved, or the provisions were proved, or the provisions were struck down as unconstitutional. And in my case, for example, I would have paid the tax. I would have filed. I would have paid the tax. I would have possibly filed for the court saying that, you know, the tax is not leviable and all of that. Court rules against me in my case, and I will just stop at some point. I will stop fighting. I will agree that, okay, fine, now what to do? And I will go ahead and continue doing my business. But after a few years, maybe 1 year, 3 years, 20 years, 30 years, etc., in somebody else's case, maybe on some other grounds or whatever, the same tax would be struck down as unconstitutional or without jurisdiction. Then what happens? Can my case be reopened? Can I use that judgment and say, see, I had paid tax 20 years back for the same same taxability or same taxable event? I have to also get refund. Can I do that? So the judgment says, no, once my case is finalized, I can only go to appeal. I can only use the remedies under the statutory provisions. I cannot reopen the case after limitation. And if there is any refund that comes in, I need to apply under the provisions of the Act. Just because after 20 years, somebody else has, the matter has been favorable for somebody else, I cannot open it in my case. So similarly, in Mafat Lal's, the judgment was against Mafat Lal because it went and it filed for refund because of Calico Mills case. And it said that, it could not prove unjust enrichment. So Mafat Lal got a negative ruling.
So the Mafatlal got negative because of the limitation.
Because of multiple reasons. One is limitation. The other one was, main was unjust enrichment, that the Mafat Lal could not prove that the incidence of tax was not passed on. But they also discussed limitation. They also discussed whether I can go under writ for refund. All of these were also discussed. But main thing was unjust enrichment in case of Mafat Lal.
Okay. So had the unjust enrichment was not there and it was paid during assessments or anything, and it is not collected from the customer, it wouldn't have traveled?
That's an interesting question, and I'm going to cover that.
Okay.
What about assessments? Is assessments final? Can I say that my assessment is not final just because somebody else has got a favorable order? All of that is also discussed. So let's go over that.
Dhanashree, just one doubt in your slide for refund under excise. Is it 3 years or 3 months?
So earlier it was 3 months only. Here,
that's correct.
By September 91, it became 6 months.
Okay, okay.
So basically, once 11B came in, it became 6 months. 6 months from the relevant date, both for demand as well as for refund. Demand also, under normal provisions, it was 6 months. And refund also 6 months. Remand, of course, if there was fraud, etc., the limitation period was extended.
Sujata madam, initially the concept of limitation in the indirect taxes was that actually, I mean, normal period is where you have indirect tax is supposed to be collected from the customer and paid to government. If it is not intentionally done, unnecessarily should not be burden the taxpayer. So within 3 months means they can at least go and catch the customer and able to collect and pay. So that was the purpose for which it was originally kept only that 3 months. Then it increased to 6 months, then 1 year. Then in service tax, we forgot this basic principle and moved to 30 months. And in excise, it was increased to 2 years. So what I always say is, we miss this concept of unjust enrichment vis-a-vis, the aspect of limitation vis-a-vis the concept of indirect tax, that the fact that I have not collected the tax is a essential factor which, policymakers should look at. But unfortunately, what happened was, all the most 90% of the cases were succeeded against, by the taxpayers against the department only on the aspect of limitation. So they had to look that seriously and try to. I mean, in fact, if you see 70-74, they removed the entire concept of limitation for issue of notice. They converted it only as a matter of a penalty only. So what if we essentially fundamentally we look at it, the principle was being an indirect tax, you should not be asked to pay out of your pocket was an essential principle behind that distinction between normal period and extended term limitation. Unfortunately, that fundamental has been lost sight of as of now. So when they said that for demand is a limitation, even for the refund also the same should be the limitation. That's how it went on. Though the demand limitation period increased, refund limitation period was not increased in the excise or for that matter service tax.
Oh, okay. So under GST, if even though they give 2 years from the date of invoice or realization, whatever it is, so it is not good for the taxpayer if you look at it that way.
No, from the limitation perspective, I'm telling.
Limitation perspective.
Okay.
Like more time period they give, it is not good for the taxpayer, because in case if they are not able to, achieve it through refund through proper mechanism 54 or whatever, then they will lose.
Refund is okay 2 years, but I'm telling the demand period. I'm telling generally. I'm telling a demand limitation for demand. Okay. Okay. And I mean, anyhow, we are discussing on Mafatlal on this aspect of unjust enrichment, the incidence of passed on. I think you should also refer to Addison's Supreme Court decision, which is may have to read it together, where the credit notes, whether it can be. She may explain it, but I'm just telling, be also conscious of the one more decision of Supreme Court, Addison's. Okay, you can proceed, Dhanashree.
Thank you, sir. So, Kanhaiya Lal case of 1959 was one of the first cases or the landmark judgments. I think this was a 7-judge bench or 5-judge bench. Kanhaiya Lal was a 5-judge bench in 1959, which talked about this mistake of law. So they paid taxes for, they dealt with forward transaction in silver bullion and paid taxes for 3 assessment years till 1951. Then in another person's case, that is Budh Prakash Jai Prakash, it was held that a tax on forward contracts was ultra vires. So Kanhaiya Lal went ahead and filed a suit. Like the High Court allowed it, and then Revenue appealed to Supreme Court, and Supreme Court also allowed it. However, in Kanhaiya Lal's case, unjust enrichment was not discussed. Limitation was not discussed so much in detail. Basically, it just said that limitation is under Limitation Act, and 3 years after the mistake was discovered is when the limitation starts ticking in. So they didn't look at the provisions of the excise law so much, and they just ruled in the favor of Kanhaiya Lal, saying mistake under Section 72 of the Indian Contract Act means both mistake of fact and mistake of law. And these people are claiming refund under mistake of law. So and since they have paid taxes, which is beyond the authority of law, as per Article 265, they said that the refund is valid. And this is what they said. And generally, it was followed after that in 1965 by a 7-judge bench in Aluminium Industries case, and Bhai Lal Bhai's case also in 1964. So what Mafatlal is talking, or how Mafatlal criticized Kanhaiya Lal's case, saying, first thing they said, or some of the things that they said was maintainability of writ was not discussed at all in Kanhaiya Lal. Whether the refund has to be gone under the statute or writ was okay, that part was not discussed in detail. They just went ahead and saw, okay, they have paid tax beyond Article 265. So refund is applicable. They have come before the limitation of 3 years passed because they understood or they discovered the mistake of law only later. Limitation was applied only later, and so the refund was given. So these were the criticisms. Article 265 is to be read with unjust enrichment. Special law is more special law is greater than general law, and excise or the Customs Act or the special indirect tax laws were all fully codified laws. So once the law is fully codified and all the remedies are given under the law, it has a tribunal, etc., then the refund, etc., have to be under the special law itself. The suit for the civil suit cannot be filed. If SSC 1 loses a case and limitation for next appeal is over, for example, in Kanhaiya Lal's case or in Mafat Lal's case, they lost the case and their limitation under the specific statute is over. However, some other SSC wins the case, then SSC 1 cannot reopen once a limitation is over. Section 72 of Indian Contract Act is not applicable once the provisions of the special law are detailed and fully codified. Indirect taxes are presumed to be passed on statutorily unless rebutted. And the idea of unjust enrichment is inappropriate in case of revenue or state, which is in the position of parens patria or parent of the country. Even from constitutional angle, right to refund under unconstitutional provision of law is not an absolute or unconditional right. Unjust enrichment has to be proved. So I'm just taking through some of the judgments discussed in case of unjust enrichment, but not in case of excise in other indirect tax matters. So in Shiv Shankar Dal Mills case, the challenge to market fees collected was struck down. The market fees was hiked from 2% to 3%. It was struck down as bad. So the traders who had paid this market fee demanded refund. It was held that since the traders had already, or the traders or the middlemen had already passed on the market fee to the end customers, the refund is not applicable. The refund is applicable only in cases where the traders can prove that the incidence of tax or the burden of tax was not, or the burden of fee was not passed on. Similarly, in Amarnath case, Amarnath Om Prakash case, which came in later, traders had paid the market fees and claimed refund. It was struck down saying refund only if the trader show that he himself bore the burden. And here markets committee could retain, similar to how our consumer welfare fund could retain if there is excess tax paid and the burden is not passed on, the consumer welfare fund can retain. Similarly, here the markets committee could retain the fee if the burden is passed on to the next or to the consumer. Here in Venkat Lal's case, the director of civil supplies issued a notification fixing ex-factory prices for sugar for factories. Venkat Lal was a sugar mill, and it said that since in this case supply price was greater than the ex-factory price, so they asked the excess price to be credited to the fund, and mills credited to the fund, but they also went ahead and asked for refund. It was held that the refund is not automatic. Court emphasized two things: limitation and unjust enrichment. If the SSC has passed on the burden of tax, the refund would unjustly enrich the mills and the money cannot be refunded, and it was credited to the Madhya Bharat government sugar fund. who used it for the general welfare of the public. So this, like I already discussed, these were the principles that were discussed in these three judgments, that even when refund claims are made under the general law, that is the Contract Act or writ jurisdiction, they are subject to the doctrine of unjust enrichment. No SSE can recover the taxes, fees, etc., unless he pleads and proves that he has not passed on the burden of tax to others. Otherwise, the refund would result in a windfall to the SSE. The SSE would be rich unjustly. Public interest versus private interest was also discussed. If the taxpayer has shifted the burden, refund to him is inequitable. Money should remain with the state for the public purposes. And unjust enrichment was not a thing for the state. State holding the money is not unjust enriched. State is not unjustly enriched, since it is not at the expense of the claimant, and the state would use it for the public good. And that is how unjust enrichment is only in case of persons or the taxpayers who collect the tax and pass on the duty and then want to claim the refund. Then in 1966, Kamla Mills was another 7-judge judgment. In this case, the main contention which was discussed was, can civil courts entertain refund when the Act bars jurisdiction and provides its own appeal or revision scheme? So Section 20 of the Bombay Sales Tax Act, I have just put the Section 20 over here. I'm just going to read it out. We have similar provision in GST as well. Save as otherwise provided in Section 23, no assessment made, no order passed under the Bombay Sales Tax Act or rules made under by the commissioner or any person appointed shall be called upon to question any civil court, and save as it provided under Section 20. So basically it's saying that once the assessment is final, once the assessment is final in a particular act for a particular SSE, and the remedies under the act are exhausted, appeal, revision, etc., then that is final. There is no other, I cannot go beyond the act and go under a normal civil suit for taking care of my assessment, saying this was all incorrect. So Kamla Mills was registered under the Bombay Sales Tax Act, and it was assessed on certain sales as inside sales. And later in another case, it was recognized that the same sales was outside sales and not taxable under the Bombay Act. Inside sales means under Bombay, in the state of Bombay. Outside sales is like export, which is not liable to VAT. So by then the statutory remedies or appeal, revision, etc. was expired, and the Mills filed civil suit for refund. So it was rejected. So this was one of the major precedents which was relied upon, which said that civil suits jurisdiction is barred where statute creates a special right and where statutes provides a mechanism for determination, and statute gives remedies similar to civil suits. Then you can't go under the civil courts. This was also affirmed in Furman Illuri Subbaya Chetty Sons and Dulabai versus State of Madhya Pradesh.
Your voice is not audible.
Is it audible now? Okay.
So Kamla Mills kind of overturned Kanhaiya Lal case.
So Kanhaiya Lal did not talk about the maintainability of the of the, what is that, petition under the civil suit. That was not discussed at all. That is where Kamala Mills comes into picture. Kanhaiya did not discuss two main things. One was unjust enrichment was not discussed in Kanhaiya at all. And maintainability of the suit also was not discussed.
But the
just
claim was
mentioned-
under civil because the statutory timeline got expired.
Come again?
In Kanhaiyalal's case, the refund was claimed under civil procedure because the statutory time limit got expired, and the time limitation they started reckoning from the date of mistake of law, and that's what. So it has,
Correct.
since it is claimed under civil law, so the examination, is it required because they have entertained under civil law? So that means, can we not presume that that holds good?
Correct, exactly. So both unjust enrichment and the entertainment of the petition under the civil code was presumed to be agreed, but they were not in detail examined. And the judgment says that if these two were presumed to be okay, then Kanhaiya Lal to that extent is not correct.
Got it.
So we just finished Kanhaiya Lal, Bhai Lal, and we finished Kamala Mills. I'll just discuss Kawasdi, but we'll talk about Trilok Chand Moti Chand. So Trilok Chand Moti Chand also similarly, they paid tax. Somebody else's case was favorable, so they filed a civil suit. And it was held that once the assessee has reached finality, then it becomes res judicata for the assessee. Limitation will apply to claim refunds, and the taxpayers cannot conclude cannot reopen concluded matters. And they also have to prove that the incidence of tax is not passed on. So Mahfad Lal approved this and applied. In ITC versus Union of India also, it emphasized that the burden of proof is on the taxpayer to show that the incidence of duty is not passed on. And these three judgments form the backbone of unjust enrichment. In case of Kawasdi, what happened was it was held that the tax was collected without authority and could be refunded via writs. So Kawasdi also did not address unjust enrichment, and Mahfad Lal did not agree with Kawasdi. So far, this is like the background for the case. And now we'll go on to discuss some of the principles which were discussed in detail in the judgment. And what did the majority say? What were the dissenting views? And obviously, whatever majority says is what was followed or what would be the law. So this mistake of law thing came from section 17(1)(c) of Limitation Act, which said that where in case of any suit or application for which a period of limitation is prescribed by this act, the suit or application is for relief from consequences of a mistake, wherever the suit is for consequence of a mistake. It just says mistake. It doesn't talk mistake of fact, mistake of law, whatever. Then it says, Limitation Act says, the period of limitation shall not begin to run until the plaintiff or appellant has discovered the mistake with reasonable diligence. So it says, once I discover the mistake, the period of limitation of 3 years starts from there. That's what Limitation Act says. So Limitation Act provides period of limitation of 3 years. However, the statutes provides 3 months, 6 months, and so on, till for the purpose of Mahfad Lal's case. So BP Jeevan Reddy and 4 other judges said that overall, out of the 9 judges, 5 judges said that the refund claims must be filed only and only under Rule 11 or Section 11B of the excise law, which is a special law. special law overrides general law, and Limitation Act is a general law Limitation Act is general law. Excise Act is a fully contained, self-sufficient, codified, self-contained code. And once the adjudication is final, it cannot be reopened merely because I have discovered the mistake because of some other SSE got succeeded in the court. So it says all the claims have to be filed under Section 11. A.M. Ahmedi, who was the Chief Justice, he carved out certain exceptions where general law applies. He says, in case of unconstitutional levy, refund claims are outside the excise law, so Limitation Act applies. And in case of mistake of law also, where I find out because of some other SSE's case, this is also considered as outside excise law and limitation of 3 years applies. However, this was not what was decided, and majority is what was ultimately followed. Justice Paripuran also says where levy is unconstitutional, it is coming outside the provisions of the Act, and civil suits or writ suit remain open, and Section 72 of Indian Contracts Act Limitation Act applies. So I have a small query here. Rajesh sir, maybe you can help, sir. So here, I agree that the majority, whatever the majority bench rules, majority of the judges rule will be the ultimate judgment. However, what is the power of the Chief Justice? Because he's slightly deviating, but his words are not taken into account. So in a bench where there are 9 judges, what is the power of Chief Justice? Anybody can answer, or Rajesh sir, please.
We have sufficient lawyers in the group to answer.
Yes.
Sujata madam is there. Mailar is there. Ganesh sir is there. I don't know.
I missed out the question, madam. Can you please repeat?
So in Mafatlal's case, there were 9 judges. Out of the 9 judges, 5 judges said one thing. They were the majority. But the Chief Justice, though he concurred, he had some alternate views, and his view was not taken into consideration. He was a minority judge in case of these 9 judges. So what is the power of Chief Justice in such cases?
Like a chairman in a meeting.
Well,
I think
as
some
far as-
ratio they calculate, no, those who are against, there is some mechanism to do it. I'm not too sure. The Chief Justice is, out of 9 benches, 4 are in favor, 5 are in favor, other 4 are not in favor. So for the other 4, you have to take some kind of mechanism, some kind of algorithm is involved through which you will arrive at 8:1 or something like that. I'm not too sure. This is what I understood.
Madam, even if Chief Justice is one of the member of the bench, it doesn't confer any additional weightage as far as his view is concerned, because he is first among equals among all the judges. Just because he's a CJ, it doesn't matter. It doesn't give any extra weightage for him. So the ratio will go. The decision, judgment will be purely based on the majority, madam. Majority.
Got it.
This is nothing but like a chairman in a meeting. So what chairman, same like a CJ. So his power is majorly administrative, shifting, allotting the cases, constituting the benches. Once he is sitting in the hearing, so the majority will only hold good.
Okay.
Like a chairman in a meeting.
Okay. That's helpful. Thank you so much. So this was about limitation, saying limitation law doesn't apply to general, to specific laws or special laws, but it only applies to general laws. Venu, this is your question. Payment on own assessment versus payment under mistake.
Yeah.
So in this case, it says that payment under assessment order, is it mistake under Section 72 of Contract Act? So the majority says no, payment pursuant to assessment or adjudication is not mistake. It attains finality unless appealed under the specific special law. And whatever is the assessing authorities say is the final. It's not, he's not a collateral, it's not a collateral or a vague or a random view. Whatever he says, he looks at the information that is in front of him. Based on that, he assesses whatever he assesses, and that becomes final unless it is appealed under the special statute. So the dissenting judges say payment under assessment order is final in limited cases if levy is unconstitutional or void for want of jurisdiction. Payment even under assessment is mistake under section 72. And Paripuran says generally payment under assessment order cannot be considered as final. However, can be considered as final, and it is not mistake under section 72 of Contract Act, and agreed with the majority, and it concluded that payments under assessment are not mistake payments. What about if there is a discovery later in another assessee's case? Can this assessee reopen? The majority says that no, they cannot reopen and refund only via statutory mechanism. Both of these, Ahmadi says that it may be reopened if there is mistake of law, if it is unconstitutional, and Limitation Act applies. But however, since the majority is saying it can't be reopened, it can't be reopened basically. Is there an exception if levy is unconstitutional or without jurisdiction? There is no such exception whatsoever. And limitation law is not applicable. The limitation under the special law is what is applicable. Role of application to refund. So filing of application is considered as mandatory, section 11B, or even in section 54 of our GST law. If I don't file the application for refund, I cannot claim refund. The additional thing is I need to also file supporting evidence that the duty of excise or the duty of customs was not passed on. I have borne the incidence of tax. So since this was filed at the cusp of amendment of 1991 Act, the 1991 amendment was deemed to be the pending application were deemed to be under section 11B, that is the incidence of tax not being passed on had to be proved. Even decrees or orders of court are subject to this requirement, that is unjust enrichment and application. So Ahmadi says that ordinarily application is required, but in exceptional cases such as unconstitutional levies or lack of inherent jurisdiction, refund claims lie outside the Excise Act. In such cases, the requirement of statutory application may not apply, and the claim can be pursued to writs or suits under section 72 of Contract Act. He expressed concern that retrospective application of 11B to conclude the decrees would cause practical difficulty and suggested treating such payments as payment under protest, allowing assessees to file fresh refund application. So they're saying that if I treat it as payment under protest, then the limitation will start from the day when the judgment was reported. Paripuran says that he emphasized a lot on the duty of accounting. And he said that applicant must prove that the incidence of tax had not passed on. And he generally agreed with the majority that refund must be pursued by application of the Act, but allowed that in certain cases like this unconstitutional levies, statutory application may not be exclusive route. So the rule of the land is that the refund application is mandatory. Evidence of duty not passed on has to be also filed along with the refund application, and I cannot go to courts, trial courts, etc. For refund, and I need to file under this statutory provisions. Payment in excess, is it tax or not? Like section 76. Even if, so the majority says that even if the SEC pays excess duty, the amount is still regarded as duty or excise, so long as it was paid under the color of excise. So if I'm collecting some amount representing it as tax, it is considered as tax. Therefore, the excess payment also fall under the statutory scheme of refund. I need to fully deposit whatever tax I've collected. And if there is excess and I prove the incident of tax not being passed on, I can claim refund. However, if the incidence is already passed on, the buyer or the customer can also claim refund. He needs to prove that he's the ultimate bearer of the loss. It cannot be treated as mere deposit outside the act, and it retains the character of tax until refunded. And refund in such cases also is subject to the bar of unjust enrichment. Ahmadi distinguished a little, saying levy itself, where levy itself is unauthorized or unconstitutional, then the payment is not tax at all, but an illegal extraction. In such cases, refund claim lies outside the Excise Act, and excess payment need not be treated as tax. What is the authority of the proper officer to examine refund? So, the majority says that the proper officer is of ultimate authority. He has multiple very, very important tasks. One is to scrutinize the application, verify whether the unjust enrichment has been, whether there is no unjust enrichment or the duty of incidence of duty has not been passed on. Decide whether the refund should go to the claimant or should it go to the consumer welfare fund. And he says that the refunds cannot be granted automatically, even if there is a court order. The refund has to be filed, or the application has to be filed under the section 11B, and the proper officer has to examine and satisfy himself before sanctioning the refund. Ahmadi also accepted that the proper officer normally processes the application. However, in case of unconstitutional levy, he suggested the refund could be claimed even outside the act, hence bypassing the proper officer in such exceptional cases. However, that was not agreed, and that was not the ultimate judgment. Limits to issues at large. So when I file refund, the question here was, when I file refund application, can all the other issues which are not part of refund also be opened up? Can they also demand tax looking at my refund application, saying, oh, you have not paid tax properly here? Can they do other things, saying, oh, you've paid incorrectly, you've done this? Can other issues be reopened? So the majority says once the assessment has become final, a refund claim cannot be used to open other issues at large. And the authority is not an appellate forum. It cannot revisit classification, valuation, rate of duty, etc. It can only see whether the duty was collected, whether it was contrary to law, and whether unjust enrichment applies. That's all. All the other issues cannot be reopened. So the dissenting view was, refund authority has no power to enlarge the scope beyond what the Act provides. The excise officer is a creature of statute. He cannot realize tax beyond section 3, nor can he insert a proviso to refuse refund if levy is illegal. Thus rejected the idea that refund proceedings could be treated as an arena for broad issues, and they must remain confined to strict statutory powers. So the dissenting judge also agreed, saying all the issues at large cannot be reopened in case of refund application. Separate mechanism needs to be adapted. I'm sure many of us have used this in our refunds, where the officer, especially in our service tax law, etc., where the officer is trying to reopen, saying, oh, this is not okay, this is not okay, you have to pay tax here, so I will give you less refund, nothing like that. So these other issues have to be opened separately, is what Mafatlal also says.
Dhaneshri, can you please go back that slide? From that slide, I'm not able to make out the difference between the majority view and the dissenting view. Can you please elaborate? Because majority view, you say once an assessment has become final, a refund claim cannot be used to reopen all issues at large. Dissenting view also, you say refund authority has no power to enlarge scope beyond what the Act provides. So can you please elaborate? What is the distinction?
There is no difference between the majority view and the dissenting view. Like the Justice Ahmadi and Paripuran also agreed with the majority view. They are basically the dissenting judges who agreed with the majority. They said that this is my view, why it should, why issues at large cannot be open. This is my logic to it. But they agreed with the majority.
Okay, so all the judges agreed that the refund authority cannot look at other issues.
Yes, exactly.
Thank you.
So I will just walk over what the issues discussed were, what the court's ruling are, and what has been the principle or what has been the legal principle followed. So the first issue was whether remedy for refund of excise can be filed only under the statutory act, or it can be done under various, it can be done under section 72 of Contract Act, or it can be done under the writ jurisdiction of section article 226 or 32, etc. It says that the court's ruling was that the refund must be claimed only under the Excise Act or the Customs Act. Civil suits are barred. Similarly, the section 72 cannot override statutory refund mechanism, and article 226 and article 32 are available, but it must be excised in conformity with the statutory scheme. So for example, if I file an appeal to the tribunal and the tribunal rejects on the principles that are such as principle of natural justice, or certain aspects were not looked into properly, then only I can go into the High Court or Supreme Court. So High Court or Supreme Court have to follow the statutory scheme, and the courts will insist on the proof of not passing on the burden. What about duty paid under unconstitutional provision? They say that the refund is possible via writ or suit, but it is not automatic. Application, etc., needs to be filed, and the claimant must prove that he is not passed on the burden of duty. Duty paid in the mistake of law, that is in another SSC's case, final assessments cannot be reopened, res judicata will be applicable, and refund is to be done only under limitation rules of the Act, and the finality of the proceedings of the limitation applies. Unjust enrichment is always strictly applied for all refund matters. Presumption that indirect taxes are passed on to the customers, and burden of it is the burden of the assessee to rebut. Doctrine of unjust enrichment always applies. Validity of 1991 amendments. All the amendments are valid. 6 months limitation period is valid. Consumer Welfare Fund is legitimate. There was a discussion whether Consumer Welfare Fund is only a pretense. I'll just come to that. Whether consumer welfare fund is only a pretense. So the court said that it becomes, it is ill becoming of the manufacturer to advocate the cause of the customer when so far they were making a killing at the customer's expense. So suddenly they cannot say that, oh, consumer welfare fund is a pretense, because they are asked to prove that the burden of tax was not passed on. The buyer can apply. The buyer also can apply for a refund and prove that the incidence of tax is borne by him alone, and he will get the refund. So consumer welfare fund is not a pretense, and it will be used for the public good. So this is the overall view of the judgment. I have a couple of doubts, and I want to also discuss how Mafatlal's judgment is applicable today in GST 2.0, because the rates have changed, the prices are changing. Should the prices change? How should the taxpayers look at this? So there is one small discussion in the judgment about contract price, whether it is inclusive of tax, and what happens in case of firm price contract. I would request Rajesh sir to help me out here, because the concept here is not very clear for me. However, let me explain. So when contract price is inclusive of tax, it means that the goods are sold at a contract price, which is inclusive of tax. The entire price, including the duty component, is recovered from the buyer. In such a case, if later the refund is to be granted, the seller should prove unjust enrichment. And if he's not able to prove, then it'll go to consumer welfare fund. However, if there is a firm price, irrespective of whether the duty changes, then the seller bears the burden himself. I did not fully understand how this is possible. There is also certain discussion in the judgment which talks about, if the seller sells at a loss, then who bears the duty? Whether the nature of excise duty changes, whether it becomes somewhere like a direct tax, because the seller is sort of bearing the duty himself and not passing on. So there was some discussion around that. If Rajesh sir could sort of help us with that, and how it is relevant in today's context, especially because I found that very important, but I couldn't fully grapple what it meant. Rajesh sir? It's also open to all of you, because now with the with immense rate rationalization, how are we looking at this unjust enrichment piece?
Dhanashree, I vaguely remember, I'm not in front of the system or my reference material. There is one Ramki Industries or something, right, where they had entered into a contract with their customer for a cum duty. Okay, where the agreed price is inclusive of all taxes. So the company was not sure about the tax applicability. So what they did, they paid under protest, thinking that they can claim the refund at a future point of time. And later they realized that the tax is not applicable. So they went on to claim the refund. But ultimately it was rejected, stating that your contract says come duty, and whether you have collected or not is not for us to prove. So we, as per the law, we have every right to presume that you have collected, and refund was rejected. because if they offer the, if they, approve the refund, it will be treated as a unjust enrichment. So there was something connected to what you are saying. I am not able to recall. Maybe I will just check my laptop and come back to you. When the contract is silent.
When the contract is silent, it is always presumed that the duty has been passed on.
It's been passed on, is it?
Yes. So our section 49 also says that, I will actually read it out.
But in this one, recently in one real estate judgment, we see that the buyer was, the landlord has entered into agreement with the developer stating that it is a he will take care of, that is the developer will take care of the tax liability, but still, then what will happen to the buyers who have paid the taxes? Will they be eligible for refund? Something, there was a change in the recent times. Last time also we discussed. You remember, maybe I will forward if I have that handy.
Look at it. Actually, I haven't looked into Addison's case, which Rajesh sir was referring. So I'm not sure what all was discussed there. Let me also look into that and update my PPT. But section 49(9) talks about every person who has paid the tax on goods or services or both under this act, unless contrary is proved by him, be deemed to have passed the full incidence of such tax to the recipient of such goods or services. So it is always presumed that the incidence of tax has been passed on, unless it is proved by the assessee. The burden of proof is always on the taxpayer. For whatever reason, so that's where Paripuran says that the assessee needs to focus on accounting and have all his documents very clear. And if it is possible to prove, it is only on him that that can be proved that the refund is not passed on. The authorities are always going to presume that the refund is passed on. Now the duty is passed on, sorry.
One question, a little deviating from the discussion. So in the indirect taxes, is there any statutory right to collect the tax, or is it a commercial right arising from the contract?
Yeah, actually this price related query would answer that also. So in indirect tax, from whatever I remember long back, it is a commercial so ultimately it is the statute presumes that it is collected and it is paid, but however the contract can be designed in a way that it is only a commercial thing, and the burden is not passed on, and the tax the person who is supplying the goods or services bears the tax.
Venu sir, we've heard Jatin sir saying, no, the payment of tax is a statutory obligation. Collection of tax is a commercial negotiation.
Right. But where Rajesh sir in that case, he was saying there is a right in indirect taxes for the taxpayer to collect those taxes. So maybe that Addison case is something need to understand. What was the proceedings there?
Yeah.
Yeah, again, I mean, it cannot be made as a mandate, no, to collect. But once it is a right, again, it's at the choice of the assessee and not like a, mandate.
So that is where I think this section 49 or in our excise section 12 B talks about, it's presumed that it is always passed on. However, it can be rebutted. So collection that way, I do agree that it can be commercial based on the terms of the contract. However, it is always presumed that it is passed on unless it is proved. So that commercial decision has to be proved in the court of law, especially wherever there is a refund.
Because for unjust enrichment, you have to clearly establish that it is not passed on.
Yeah, you need
and
to.
If section 49 explicitly says that it is deemed to be passed on.
Yes.
So every refund case has to be tested that okay, like unjust enrichment kind of fails from the SSC point.
No, it's a rebuttable presumption now, Venu sir. Like our 155, whatever, like it is a rebuttable presumption. The presumption is that it has been passed on. It is on the assessee to prove that it has not been passed on. By default, it is presumed. If you want to counter it, then you have to produce evidence in proof of it.
So 16 subsection 2, where the value of goods and taxes should be paid. And we have indirect tax where it is where there is a B2B transaction where I pay the tax and the other person take the credit. It is a flow of chain where it is a value added tax and each taxes will flow to the next person. So all these are very built into the act where I am eligible to collect the taxes. Because of this very process or very fundamental of the tax itself shows that the burden has been shifted to the person to the other person. The enrichment can be proved only in B2C cases where we have a contract and other thing to say that supplier himself is incurring taxes. All these things very difficult to prove, but in case of only B2C, then it can be proved. Because in B2B, it is very difficult to prove the unjust enrichment because of all our invoices, collections, where the input tax credit has been passed on. All these things are very well visible in the portal itself.
Yeah, correct. In fact, our section 34 also talks about in case of credit note, and I think Rajesh sir was mentioning about Addison's case in credit note or something. So I will look at that. But our section 34 also talks about that credit note can be raised only when the credit note is valid only when the incidence is not passed on. That needs to be proved. So it says 34(2) says no reduction in output liability if the supplier is permitted if the incidence of the tax has been passed on to any other person in such cases. So if the receiver is claiming the credit, then credit note is invalid. I need to reverse. So any questions, or I can walk us through some of the golden, what do I say, words in the judgment. Basically, this is what is the judgment.
Would you be running through about the concept of parens patria?
Yeah, I can run through that.
Okay.
So concept of parens patria is basically that the state is the one moment. So state is the parent. Basically, that's what is the concept. It says that if the state is in a position to do public good, and hence it cannot be said that the state will be unjustly enriched. That is the concept of parens patria.
Yeah, so given a choice that there is this unjust enrichment available to private parties and unjust enrichment available to state, the preference would be that unjust enrichment lie with the state because it will do the public good rather than transfer it to the private parties' benefit.
Correct, absolutely, correct. So as such, as based on Article 265, nobody can collect tax beyond the authority of law. However, wherever the tax is collected by the assessee cannot claim the benefit of unjust enrichment. Maybe the state can, because the state is in the position of public good. That's what is the...
Dinesh, this Mafatlal case, how it is applicable in GST and where we can use positively and where it is negatively have an implication, like in Safari or other things.
Good question. I was about to ask.
Safari as in?
No. Any other judgment where like...
where can we use this case in today's context?
GST? Yeah.
So from what I understand or what I have been looking, entire GST law of refund has been under based on what Mafatlal has been talking about. Entire section 54, section 34, which talks about credit note. 1 minute.
Maybe to put it this way, can this principle of mistake of law still applicable under the GST law? I pay, but because of the 76 provision of 76, where once I collected something naming it as tax, I still have to deposit it to the government.
Come again, what is the question? Yes, I have to deposit to the government.
Correct. So, I mean,
says.
payment made under mistake of law.
Hmm.
I mean, yeah, again, so I've collected something naming as tax, so I have to deposit it with the government owing to section 76.
Correct.
So, I mean, again, it comes back to the same thing that unless I prove that I have not passed on the burden, I have borne it myself.
Correct.
This refund out of mistake of law would not be, would stay the same under the GST law. So I can take an example. Yeah. So I can just take an example practically of where I could think of using this Mafatlal judgment. There was this, 9/4 RCM, right? Like from 13th of October. Hello?
Yeah, we can hear you.
Yeah. So 13th of October 2017, the RCM under 9/4 was removed. So, but then many people have paid under the mistake of, whatever, mistakenly they have paid it and claimed ITC. Now, RCM is something they have not passed on the burden. Now, department has come up with the demands wherein they have happily accepted what is paid under RCM output liability, but denying the ITC, saying that it is not tax. What is paid is not tax, hence you are not eligible for ITC. So, I mean, this is somewhere we could use this Mafatlal principle wherein it is evident that I haven't passed on the burden because RCM liability, I have borne it myself. It is easy to prove. But then something paid under mistake could still be eligible for refund per se. Again, the limitation, because after 5 years, whatever, after 3 years, 5 years, way back 17-18 means it was taken up much later. By then, the time limit for refund application was also already gone. So, in those instances, can we apply this judgment is something we can discuss.
Yes, definitely. Yes, I agree that in such instances it can be applied, provided limitation is in our favor. In fact, under section 76.
No, because 3 years has gone long back. No one, I have paid in October 2017.
Yeah, that's where I said provided limitation is in our favor.
No, that wouldn't be there, no? For all practice.
Then it can't. We can't then apply for refund.
Annapurna.
I think Annapurna. Okay. Yeah. Just a minute. Rajesh, I think I missed in between because I had gone to puja. The question which Annapurna is asking that, RCM I have paid, so it is unjust enrichment will not apply. That is what you are trying to say, correct?
Yes, sir, because departments are demanding like after 13th October, whatever RCM under 9/4 was paid, they're happily accepting the output tax, but they're denying the ITC, saying that it is not tax.
No, unjust enrichment concept is essentially for a refund claiming. How are you linking that?
So, they have demanded it. Now, statutorily, I've lost the right to apply for refund under 54 because 2 years timeline is over when assessment is taken up and this mistake is realized.
No, this mistake means it is, you are talking about taking input tax credit, not refund. Na? It is not a wrong payment of tax. You are talking about any wrong payment of RCM liability?
Yes, sir, because after 13th of October 2017, 9/4 RCM was removed. But few people continue to pay and pay the credit. Now, department accepted the output liability but denying the ITC.
No, there are
2 years
two
time
different
frame.
things. There are two different things. You cannot mix up the two. As far
Okay.
as the refund is wrongly paid tax, you should have gone ahead and claimed refund. Okay.
Liability
Within the
and
time limit prescribed.
okay.
Okay. There you're hit by limitation. So then you cannot claim refund. Merely by the fact you have paid something which was not payable, you cannot claim an input tax credit of the same.
Yeah. So my
So on-
ITC has to be reversed, but I'll have to file a refund of the wrongly paid RCM.
Yeah, but again, the argument what you are saying is that I paid it as a, so I'm eligible as a thing. That's a different argument which the courts will see. Okay. Second thing, I think the Mafatlal has set out certain principles. One, when the refund has to be made outside the statute, when a refund has to be made within the statute. If you are the petitioner in a writ and where the constitution, the provisions held to be ultra virus and you have paid the tax, then you can claim outside. But in somebody else, you are taking that is a mistake of law. So you have to claim refund within the framework of law. I think that is a principle. Correct, Dhanashree?
Correct, sir. Yes, correct.
Okay. So now coming to the once you are hit by the provisions of the act, you are supposed to file a refund in terms of the provisions of the act. The limitation has to be applicable. So you cannot ignore the limitation. You have to strictly follow the limitation. That is the second aspect which we need. Third aspect which is said is irrespective of the refund, whether within the statute or outside the statute, the principle of unjust enrichment has to be proved. That is, you are not passed on the incidence of tax. So I think then there's one more principle in between it is spoken. If you are
Cannot go to courts.
Sorry?
Cannot go to courts.
Yeah. No, not that. I'm talking about in the context of the payment and the protest. Payment and the protest. See, once there's something called a deemed protest concept also. What it says, there's one show cause notice. You are contesting the show cause notice for that period. Subsequent periods, you are paying the taxes. So the period when you are contesting the issue for the earlier period, the subsequent period payment shall be deemed to be paid under protest. So there was no need. Now the first question which comes in as far as this protest, there was a specific provision in the Central Excise Act and which was made applicable for service tax law, that this time limit is not applicable when the taxes are paid and duties are paid in the protest. But we do not find similar provision in the GST law. Okay. So when such thing is not there, can we still apply that principle? Because whatever we have paid in the protest is actually not in the nature of tax. So I should be given relief. I think the court has to come out and say, as of now, that is where Jatin sir always say, you have to claim back a refund within 2 years because that exclusion of the payment, the protest, or is not available in the GST law. So then this unjust enrichment concept, one which is prima facie appears through invoices. We're discussing about that, portal, etc., etc. But there is a decision of Supreme Court in case of solar pesticides. You should note down that solar pesticides, where it says it is not only a directly passed on, even indirectly passed on should be not there. Which means that merely, in fact, for example, assume what Anpurna was giving an example, it was claimed within 2 years itself. Now the question which comes in is whether that whatever RCM was paid, whether it was included in the cost of the goods and ultimately collected as the cost of the goods from the ultimate customer, still the incidence of tax has been passed on, so unjust enrichment will get attracted. This is what is the principle of solar pesticide. Okay. So I think the another principle which I was trying to explain was additions, where that I raised an invoice, subsequently I issued a credit note. So as far as at my stage is concerned, I have nullified the effect of tax, but doesn't mean that that further my customer has not passed on the benefit, I mean, the tax instance to the further persons. So they say you need to prove ultimately that has not reached to a customer. It is completely reversed from the consumer end till the stage where you are. I think that is where the principle of unjust enrichment is being emphasized on. So, because concept of unjust enrichment is that this is being an indirect tax. Once, why is a presumption? If you are collecting a tax from the consumer or a customer, again, if the government gives you, you have collected and paid to government. Why should the government give you the money? I mean, that amount of extra paid tax. That is a principle of unjust enrichment. So, keeping that in mind, these are the decisions which will be there. Probably in the GST perspective, as was pointed, one is a protest. There is no such distinction, no provision. So maybe we need to be cautious. What I think. Other things, I think we can discuss.
Sir, what about in the current scenario, sir? Is unjust enrichment only with respect to refund, or even in terms of the current scenario where the price changes are happening, would unjust enrichment?
No. That is not unjust enrichment. Only applies on a refund cases.
Okay.
We may use the term unjust enrichment, but the principle what is stated earlier was that 2 times benefit. Basically, unjust enrichment, you're being enriched twice. One, you collected the taxes from the buyer, and at the same time you are claiming it from the government. So this the concept what we are discussing in the Mafatla is in that context. But this word can be used in generic terms wherever government is unjustly enriched. All those wordings we use, which can be used. But where is the question of unjust? It's a commercial transaction.
Right.
Okay.
So in terms of the pricing, Jatin sir had asked me to look up what does contract price inclusive of tax versus firm price contract mean in terms of unjust enrichment. I did not fully follow that part of the judgment.
See, I think couple of decisions are there, but may not be a Supreme Court. Say, for example, I quote a price inclusive of taxes. Now, I initially paid a tax in the GST 18%, but actually my tax was payable at 12%. I made the tax payment inclusive. Come tax working out, I did it. Customer, I have not specifically told. Later on, I realized I have paid extra tax and I revised it and claimed a refund of extra paid tax. Whether in such a scenario the incidence of tax has been passed on or not, I think that context Jatin sir has told, which is you need to examine. That is a inclusive tax firm contract. Other thing is a firm contract. Irrespective of the increase in price or decrease in price, you are supposed to be paid only that. So in that scenario, what happens to the tax element contained therein? I have not made a study, but I'm just telling that what Jatin sir has told is in this context.
This context. Got it, sir.
Rajesh sir, in terms of limitation, let's take the same example of 9/4 payment made after the date when there is no levy. So whatever taxes I've paid, it is in the nature of not a tax. It is a wrong payment. So this Mafatlal came up with 3 distinctions. One is unconstitutional levy, illegal levy, and mistake of law. So if we fit this payment under 9/4 under unconstitutional levy, because it is not a tax at all. So
no. I think that may not, in my opinion, no, because constitutional levy, as it was told that you should be the person who is taking that. It is not a constitutional at all. It was there. You have mistaken of law, mistaken of facts. You have mistaken and paid. The law did not say anything. Law was clear that you went ahead and paid mistakenly.
Okay, so in that context, if I enlarge this understanding further, so in this Mohit Minerals case, on import of services, they had paid the taxes. So that is treated as unconstitutional.
No. Mohit Mineral didn't say that. Mohit Mineral only said that valuation principle, no? basically it's already included in the valuation. Composite supply was the essential basis, no?
Correct, but they also said that why should I get back the amount what I've paid back is because it was unconstitutional, not because of mistake of law.
No. What Mohit Mineral, what does it say? Can you just refresh?
I don't have the case laws here, but it just said on two things. One is on the valuation, saying that on the value, when it is FOB value, it is inclusive, so you cannot collect taxes again when there is a valuation is decided in such manner.
Correct.
And why should I get the refund of it? Because then the limitation will kick in. If I say it is a illegal levy, but
No,
there is a
the
distinction.
you challenged before the court and it was held to be invalid under the unconstitutional levy. Then they said you can claim a refund beyond the act, correct?
Right.
So that will be applicable in that case. But you following, you are not a appellant, I mean the petitioner in that case. You are separate, independent.
Yeah,
Sorry?
that is right. But if I'm a petitioner, I become a party to a case, and then will the limitation apply? Because any taxes, any amount paid which is not taxes, which is not a tax at all.
Your example initially was different. Now what you're telling is different.
Okay. No, I wanted to basically ask that when any amount is paid which is not a tax, will the limitation apply or not apply?
Presently, you are finding a lot of case laws coming saying that it is not a tax, limitation not applicable and all. But I think nobody is stressing or looking into the aspect of this Mafatlal. If the department wants to really take it up, I think then it can become a challenge. You may find many decisions off late which are coming saying it is not in a tax or limitation doesn't apply. Simply the courts are following or the tribunals are following without bringing in this concept. If somebody seriously argues, then there will be a problem.
Okay, because this has gone up to the constitutional bench, 9-member bench, and still they are not following this in its true
Not
spirit.
following, it is not brought to the notice.
Okay.
During the course of argument, they will not emphasize that. Either the party brings in or not the department side brings in.
Oh, okay. Fine, sir.
For inferior models.
Okay.
Sir, I have got a case where what has happened, there was a supply which was considered as exempt, but later notice was issued and it was said that the supply is taxable. It is litigible. The client did not want to fight. So they said, okay, go ahead. I will just go ahead and pay the tax and close the matter. I'll pay the interest also. And they have put in the payment of tax saying this is paid in the protest and gone ahead, paid the tax. The order has come in saying, we agree that this is not liable to tax. And they have issued an order, something like that, where in the passing, they have mentioned that this is not liable to tax. So now can the SSC go for refund saying the incidence of tax has not been passed on? 1. 2, interest also, can they claim refund going under Mafatlal case?
No, but you have not contested that demand, no? In your whatever the petition.
In the demand, I have contested saying, see, this is the reason why it is not liable to tax. However, since the amount is smaller, I'll go ahead and pay the tax. I don't want to fight. To buy peace, I'm going ahead and paying the tax. They have agreed to this one. We agree with the taxpayer that it is not liable to tax. And however, they have paid, so we are going ahead and accepting the tax. Something like that they have mentioned in the passing.
I think we have to look into the facts of each case. But the problem is, once you have admitted that I am not going to contest, and they have not given. I mean, you have not given an opportunity for them to rebut your fullest ground. Okay, there may be difficulty. You can claim refund, practically, but whether it will then a refund, it will get opened up. Legally, you are entitled to claim a refund, and you may also get also.
Okay, but it may open up. You're also saying.
You told the amount is small. Will it be worth fighting that refund to the higher tribunal level? Is what you need to think, because at the first appeal and second appeal, they will not get the refund.
Got it. Okay. Fair. Thank you, sir. Makes sense.
Venu?
Venu, I think, is dropped off because he had.
Dhanashree, just one final word. If you can just crisply tell us with this Mafatlal judgment, as we stand today in GST while claiming GST refund, what are the principles, key principles we can use from this judgment?
Key principles.
Limitation or whatever.
Yeah, key principle.
Where do we use this judgment? How is it relevant today for claiming my refund under GST?
Yeah. Key principles. One, refund has to be applied only under the statutory provisions of the GST law. Two, limitation under GST law applies. That is 2 years from the relevant date has to be strictly looked at. We can't go to the limitation law. Three, in case we find that some levy is unconstitutional, we can go ahead and go to the courts, etc., for getting a proper judgment that it is unconstitutional. However, unjust enrichment has to be and if the court says that, okay, this is unconstitutional, unjust enrichment has to be always followed while getting the refund. Then, yeah, payment under protest was there earlier, saying whenever you pay under protest, limitation law doesn't apply, or the limitation till that extent is not applicable, and only later the limitation starts. But in GST, payment of protest is not there at all. Yeah, these are the major principles. The courts are barred from taking up cases, and it needs to be done under statute.
Sujata madam,
yes, sir. Yes, sir.
Put it little differently. Okay. This decision, the principle you need to take in this decision is not to, litigate in your favor. It is more to take up precautions, what you need to defend on, and create a documentation to overcome these hurdles. So these are whatever the principle set out in Mafatlal is against the taxpayers. Okay, rather it is not facilitating the taxpayer so easily. So you need to keep in mind, okay, these are the hurdles which I want to get. How do I overcome? So in that angle, you need to see the documentation, how to put across, what to support the documentation to prove that unjust enrichment is not there, all those things. So you need to use this as a guide for you to how to make your case better, not to use this in your case.
Correct, sir. That's what I also feel, because everything is knocked off. No, like unless you apply, we are not going to get. And notwithstanding class for that consumer welfare. So everything, time limitation, tax law prevails. Everything is like one by one struck down by looking at the judgment. So where do we stand? Probably, this is the only one hope that, okay, this refund has traveled for so many years. So it is giving some hope. If at all anything is rejected, we can go to the next higher forums. If there is, unjust enrichment is not being, in spirit, it is not being followed. So that's the only hope. Is that what we are getting out of the judgment as we stand today?
I think practically you see a lot of decision after this order also not following this decision, giving some decisions. Okay, you will because somebody would have not referred to this or given this argued from the department so strongly on that. Off late, you can anything which is service tax, there you may find at least 50 cases where they say you are wrongly paid some tax, so it is not a tax, so unjust enrichment doesn't apply, limitation doesn't apply. You will find many decisions of tribunal. So,
but Mafatlal, that way is clear. Whatever amount you pay.
Mafatlal says, but none of the decisions have looked into Mafatlal and followed it. What I'm telling is all those decisions are effectively per incurium decisions.
What decisions, sir?
Per incurium. Basically, that any decisions which is not considered and they already decided proposition and given. So I think people will be using those cases unless somebody comes out, and so this is like knowledge we need to know and try to protect wherever possible, but try alternate things also. This is practically I can suggest.
But this Mafatlal one where we are using in advantage of the taxpayer is how this in case of RCM how Annapurna Shrikant brought out. See where the one more principle which Mafatlal has brought out is once you pay the tax in mistake of law, it will take the color of the tax itself. So because of that, when they demand for reversal of ITC, it is not the right option to reverse ITC and apply for a refund of output tax. The only argument that we need to take in respect of the Mafatlal to say that it is takes the color of a tax by mistake, because the tax is paid by mistake, it will take the color of tax. So ITC should be eligible. So we should take that contest and continue to say that ITC is eligible because of the Mafatlal. Because Mahatla says whenever there is a mistake of law, we have to apply all, including the refund, everything as per the statute. So it will take color of the tax itself and not any other amount. So based on that, we should be eligible to claim even ITC of the RCM, which is paid under mistake of law.
I think good point to take, but we'll get tested.
Correct, sir.
Okay.
And Raji sir, you mentioned that mere issue of credit note will not establish that there is no unjust enrichment, that it has to be proved even at the level of the buyer. So what document can be produced and what groundwork has to be done to establish that there is no unjust enrichment?
They have not set out any such things, madam. Basically, it's your to prove, you bring in what documents you want to establish. Say, for example, in case of a developer, there's only one consumer, correct? The next level cannot be passed on. You issued a credit note to the buyer of a house. Whether he can further pass on, no, because he is not in the business. Same way, wherever the B2C, if you're able to establish that whatever the supply you have made is B2C, and you have issued a credit note to him, then obviously B2C means basically again not in the context of your GST B2C, in the business sense of B2C. So then you can, if you are able to establish he's a consumer, final consumer, then no problem. If next one more buyer, you're a whole manufacturer is a wholesaler and a consumer, or I mean another dealer and a consumer. So then again he would have also passed on such benefit, or it was credit notes were issued before he sold the goods to the customer, something like that. There is nothing like a universal formula or a document.
Okay.
Sir, I have a small doubt. Basically, we are saying that excise and special laws, wherever are complete, then we cannot go to courts for writ, etc. So tribunal is the ultimate authority. So when we go from tribunal to High Court or Supreme Court, those are called as appeals and not writs, correct, sir?
Yes, yes.
Okay.
See, writs is basically for your principles of natural justice, is basically the your fundamental rights. One is the fundamental rights, violation of fundamental rights, and something which is what they say,
Ultra virus.
Ultra virus.
Jurisdiction,
ultra virus, fundamental rights, and for the from the High Court stage is concerned, something which is unreasonable also is there.
What exactly is jurisdictional ultra virus, sir? There is some discussion in the judgment about that, but I fully didn't.
Jurisdiction is basically, instead of Bangalore commissioner issuing a show cause notice, your Mysore commissioner has issued a show cause notice.
They also say that wherever the authority is right, the jurisdiction is right. Wherever the authority is looking at law incorrectly, that is also incorrect jurisdiction. So
no, jurisdiction is a wider connotation. You have to see from the context in which it is used.
Okay.
Like subject matter jurisdiction, pecuniary jurisdiction, territorial jurisdiction.
Okay.
So what you are referring is a subject matter jurisdiction.
Okay. So if at all the authority who has the territorial jurisdiction is going beyond subject matter jurisdiction, then also I can go to writ.
Any jurisdiction outside, you can always go in writ.
Okay.
To add,
Okay.
sir, jurisdictional error can be of three types. Either it is a limitation issue. Officer is trying
Ganesh
to go
is
beyond.
is off late arguing various courts on jurisdiction many times. Tell Ganesh, explain. Explain, Ganesh.
Either it can be a limitation issue, like section 161 in GST. You have 6 months time outer limit to go and do rectification. If you are going beyond that and doing something, it is clearly falls under the limitation issue. That is also one type of jurisdiction. Second is subject matter. Subject matter jurisdiction is such that you are not authorized to get into certain area. Like again, I will take section 161 itself as an example, which is a mistake apparent on record. Officer has got power to rectify his notice or orders which he has already issued. In case he is trying to review or completely reverse his original notice or original order, which is not permitted under 161. So there it falls down based on this subject matter jurisdiction. And third one is what Rajesh Kumar said. It is the territorial jurisdiction itself. Mangalore officer is doing issuing a notice or order to somebody who is in Bangalore. So broadly, jurisdictional errors could be on these three scores, which courts have recognized. Yes, thank you.
Thank you so much. Makes sense.
Just one more point, Dhanashree, like in the context of burden of proof, there is one point discussed that the person who is in possession of the special and exclusive knowledge has the burden to prove. So in case of unjust enrichment, where incidence is not being passed on, the access to the books of accounts, ledgers, invoices is with the assessee. Hence, he has to prove the he has to prove the burden. I mean, that is also one of the principles which is
Correct. What was the question?
no, just bringing out the learnings from the judgment.
Yeah, makes sense.
No. First, statutory provision, where the statutory provision has a presumption towards that revenue, the automatically burden shifts on assessee irrespective of the evidence law.
True, but then that point is also discussed in the judgment. I just thought we can.
Any other questions, thoughts, comments, observations? I'm quite surprised we finished this well in time. Maybe I went too fast, I'm thinking. Okay, so if nothing, can we close? Thank you so much, everybody. It was a great opportunity to read this case and present. Thank you so much. Thanks, Rajesh sir.
Thank you, madam. Thank you, madam. Very well deliberated. Very well. Thank you.
Thank you.
Thank you, Dhanashree. Thank you.
Thank you. Okay.